professor at University of Illinois College of Law.
My name is Erin. I'm a professor at Vanderbilt University Law School.
And together we're working on a paper called Preemption and Regulatory Coordination, which is actually related to another project that we did together, a book called The Law Market, about the market for law. And in this case, in this paper, we're talking about a very hot issue today. There are several cases pending in the Supreme Court about this, and that's the extent to which the court should hold that a state law is preempted by a federal law passed by Congress. And the confusion here is that the laws usually don't state really explicitly or make very clear the extent to which they do preempt state law. So the cases have been massive confusion, and what we're trying to do is, in our paper, is bring order to the law here, and using our theory that we discussed in our book, The Law Market, to emphasize the idea of regulatory coordination.
So we're taking this idea of regulatory coordination, the fact that sometimes states can coordinate the extent or the reach of their laws pretty well on their own, and the fact that diverse state laws are valuable to people who are subject to law, all of us, and we're using that principle to temper preemption principles in some cases, lack of coordination or state coordination that leads to a race at the bottom, like negative jurisdictional competition, should lead courts to use the preemption principle much more broadly. And we talk about the internal governance rule in the area of corporations, where states have coordinated themselves quite well, and so federal statutes that impinge on corporate law should be read quite narrowly. And by contrast, we apply the principle to other areas of law, like tort law and arbitration law, where federal principles and priorities in developing a national market, particularly under the Commerce Clause, should lead courts to read federal statutes much more broadly to have greater preemptive force.
And I think one thing to emphasize here is that the issues about preemption have often come down to polarized positions. On the one side, companies, international corporations, think that preemption should be used very broadly so that they can compete better nationally, because rather than dealing with 51 separate jurisdictions. On the other hand, groups like plaintiffs' lawyers and consumer regulators in the states think that everything should be left up to state law and that preemption should be very narrow. And the question is, how can these positions be reconciled into a meaningful rule? And I think that our approach about regulatory coordination is one way to accomplish that accommodation between the two positions.